The Honourable Shane Mallard.
Thank you, Mr President. I rise to make a contribution on the Reproductive Healthcare Reform Bill 2019 and in doing so attempt to put my reasoning for my position on the public record. I believe each of us owes the people who give us the great privilege and honour to be representing them here in this place the understanding of our reasoning in decision to make, and particularly on such a touchstone issue as abortion. Each of us stands here, a product of a life journey to get here. This can be our early upbringing, our family values, our early role models that influence our development, our teachers and our education, and for some, religion, which is the foundation of their beliefs and values, and I respect that. As the years unfold, we are shaped by our peers and our search for knowledge and reasoning. That search never ends, and it's never perfect. For some, there is a gift of superior intelligence, and for others, and I put myself in the latter category, a stronger empathy and a drive to understand and rationalise our shared existence. And so, Mr President, I come here today, as I said in my maiden speech, the eldest child of 4, brought up in a working-class Western Sydney suburb in a lapsed Anglican family. My upbringing was reinforced by strong matriarchs, grandmothers, great-aunties, great-grandmothers, my mother, and indeed in later years my sisters, and my many, many strong, close female friends. I was taught early in life the values of family, respect, non-discrimination and equality, and I was taught very early through deeds and actions to respect women. My role model women were Menzian liberals who believed fundamentally in empowering the individual to make decisions in their own lives without the heavy hand of government. That's why I'm here on this side of the chamber in the Liberal Party. Mr President, I'm not a religious man, but not through lack of thought. Though I sometimes envy, and I can respect those who are and who can be so absolutely certain about questions that often keep me awake at night. I'm more a humanist, if not a small L liberal pragmatist. So those values and those life learnings that I've outlined bring me to this place and at this moment in time supporting the decriminalisation of abortion. My support for this issue and this bill is not a result of debates now or in the past. It's not a result of the comprehensive inquiry and report that I chaired and tabled yesterday. It's a result of an innate sense from my earliest political and social awakenings that women should be equal and that women are the best in the best position to make decisions about their own lives. One of my earliest political awakenings was the perennial issue of Roe versus Wade. Mr President, I struggled back then to understand why women's reproductive rights were in the US Supreme Court. And I thought that Australia and New South Wales in particular, we were better than that. It was only in recent years that I became aware that abortion was still on the statutes as a crime under the Crimes Act 1900. For 119 years, that has been the case, and that we are one of the last states in Australia to reform the law. For 119 years, society has sent a message that a woman's body is not hers alone, that her future was not hers alone to determine, that the heavy hand of the state denied women full autonomy and equality when it came to their pregnancy, that women could not be empowered to make decisions about their lives, that in effect women could not be trusted fully. I note in 1971, Justice Levine in the District Court opened what has effectively been the loophole that has allowed abortions to occur legally in this state. In evidence to the Social Issues Inquiry, it was put in these terms by the New South Wales Councils for Civil Liberties, and I quote, "To obtain a legal abortion in New South Wales, women have to establish exceptional circumstances emerging from the Levine ruling of 1971, that the termination is necessary to preserve a woman from serious danger to her life or to her mental or her physical health," unquote. We heard evidence that today up to 1 in 3 women have had an abortion and up to 30,000 terminations occur every year in New South Wales. A number of inquiry witnesses agreed that in effect in New South Wales we have abortion on demand, supported by a generally supportive medical profession, an ambivalent policing and legal system and a sympathetic community. If that wasn't the case, then why hasn't the Parliament since 1971 tightened the legislation around the Levine ruling? And why do authorities, the police and the prosecutors not apply resources to prosecute abortions in abortion clinics occurring under the Crimes Act 1900? And so that logically brings me to recognising that society has indeed changed and that the community attitudes are saying to us quite clearly that this is a private decision of a woman and not a criminal activity. It is logical, therefore, in 2019 to take abortion out of the 1900 Crimes Act and into its own more detailed health-centric legislation. This principle of decriminalisation had many supporters at the inquiry, including the Anglican Archbishop of Sydney, Glenn Davies, who said, and I quote, "At the moment we are resting on a judicial judgment. I do not think that's good government. I think that's your responsibilities as both Houses of Parliament are to make legislation. I have no problem about the decriminalisation aspect." That's on page 20 of the report. The bill as it stands, whilst taking terminations out of the criminal code, in fact, in my view, strengthens the regulations around terminations. For example, the limit to 22 weeks gestation, after which 2 doctors must agree to a termination, often termed late-term abortions, is a strengthening of the current law. Let's be very clear, there are no restrictions on late-term abortions under the current law. It's simply the Levine exceptions requiring 1 doctor to agree. The inquiry took emotional evidence that these terminations are extremely rare, around 1%, and usually a tragic medical catastrophe involving the unborn baby or the life of the mother. The new bill adds requirements for informed consent. That's not in the Crimes Act 1900. The new bill adds requirements to consider counselling. That's not in the Crimes Act 1900. The new bill adds requirements to review the issue of so-called gender or sex selection abortions. That's not in the Crime Act 1900. The inquiry heard testimony that there was no evidence of sex selection occurring in New South Wales. But let's be clear here too. Let's be very clear here. If gender selection could occur under this new bill, then it is occurring today under the Levine loophole. But the evidence received is that it's not. I refer members to the section on this issue in the report, section 3.100 on page 46, for a comprehensive commentary. I will extract one argument. Quote, "From the perspective of medical practitioners, the Royal Australian and New Zealand College of Obstetricians and Gynaecologists argue that current medical practice and ethics frameworks would make it highly unlikely that doctors would agree to perform a termination solely on the basis of gender. This was reiterated in evidence by Dr Vijay Roach, President of the Royal Australian and New Zealand College of Obstetricians and Gynaecologists, and I quote, "One of my great concerns when I listened to the discussion and the debate in the lower house around the issue of gender selection was that there was a huge reference to overseas populations in their own countries and in New South Wales. One of the things I found very concerning was that the discussion around the amendments effectively suggested we should concentrate on gender in a way that would end up with racial profiling. And frankly, this is offensive. Mr President, to support this claim, which was only made 7 days ago in the inquiry, we need to go no further than today's Daily Telegraph on page 7, as an appalling headline screams at us, and I quote, "Seek sex selection abortions common," unquote. If there is an issue, then let's get the evidence and devise a response. But let's not ignite a racially charged vendetta. I can hardly imagine that today every Sikh person in New South Wales feels vilified by that article, and by extension perhaps by the parliamentary debate that's underway. For those reasons I do support the sensible amendment to the bill made by the lower house. If we are to legislate on gender selection, then let's do it on evidence and factual basis and not hearsay and racial stereotyping and sensationalism in the tabloid media. So in fact, Mr President, the whole bill goes further in regulating terminations than the 1900 Crimes Act or the Levine ruling. But I acknowledge that there's another more central fundamental dispute in this reform. As the Sydney Morning Herald said on August 18, and I quote, "The bill has become a proxy for the ideological impasse between those who support a woman's right to pregnancy termination versus those who oppose abortion in all or most forms on moral or religious grounds." This is the nub of the issue. The inquiry heard much evidence from religious leaders on this point. But I was moved to a deeper thinking by the evidence of Reverend Simon Hanford, moderator, the Synod of New South Wales and ACT for the Uniting Church of Australia, where he outlines the Church's position and thinking in this regard. He says that the Church, quote, "The Church's respect for the sacredness of life means advocating for the needs of a woman as well as every unborn child." I'm referring to page 60 of the August 15 transcripts, which is available online for those who want to look that up. He then goes on to say, quote, "We reject two extreme positions, that abortion should never be available and that abortion should be regarded as simply another medical procedure. It is not possible to hold one position that can be applied in every case because people's circumstances will always be unique. We believe that abortion should not be a criminal matter, but that it is of a vital moral, social and health significance." Quote, "The Parliament resolving that this is not a criminal matter would open the health community and the wider community to better care, better support and better options for women and their unborn children." And in conclusion on that point, he continued, quote, "It is important that women have the space they need to make this difficult decision after careful consideration, and that they should have access to high-quality counselling, pastoral care and medical services. Women must be free to discuss their situation before they make a decision." It's end of the quote. Mr. President, we live in an imperfect world, a world where there are no absolutes. Socially, ethically, morally, if you will, there is a vast grey area in between. Every person in this case, mainly being women, although I note partners and families are sometimes involved in this decision, has to deeply weigh up the decision they are making in their various contexts that apply to their lives and their values. The Church has a role for those who seek it, I don't deny that. But I put it to members that the approach of Reverend Simon Hanford in the Uniting Church creates a non-judgmental environment where the Church can then engage with a woman at a deeper spiritual and moral level than the current law supports. There's no doubt in my mind, and I'm talking from experience with some close friends, that the decision to have an abortion is never, ever taken lightly. It is deeply traumatic. It is compounded by external circumstances. It is, I suggest, a decision that lives with the woman and perhaps the partner for the rest of their lives. I strongly stand by any relevant support services that a woman may need to reach out at this time in her life, whether that be medical, counselling, financial, or indeed spiritual, if she seeks that. Two other matters I'd like to address in my contribution, Mr. President. Firstly, the criticism that the inquiry by the Social Issues Committee into the bill was too brief. Now, recognising that the reference and the timetable were agreed to by this House, this is not the first nor probably the last short inquiry into legislation. But I put on the record again the key points I made in tabling the report yesterday for this debate. The inquiry was able to canvass a very broad representative sample of opinion and submissions on the bill. In particular, I noted over 14,000 submissions via the website, portal or email, 15 hours of hearings over 3 days, 15 panels of witnesses grouped into areas of interest, 44 witnesses including 10 senior religious representatives, approximately 300 questions asked by committee members, 174 pages of Hansard and a comprehensive report which we tabled yesterday. The inquiry heard from religious leaders, ethicists, rights to life and right to choose advocates, academics, women's organisations and the legal and medical profession amongst the 44 witnesses. And also I'm sure I'm not alone here in the chamber in having so far received over 11,848 emails, when I looked an hour ago, to my office on this bill. Mr. President, I thank the members who have spoken and actually commended the report. If members have not yet read the report, I strongly encourage you to do so over the next 4 weeks before we reconvene to consider any amendments. In fact, I assure members you will find there is something relevant in this report for everyone, no matter your view on this issue. Some have suggested that the inquiry could have been longer, but I put it to you that whether it was 6 days, 6 weeks or 6 months in duration, we would have achieved no new enlightenment on this issue. We would not have changed any minds. No one's position would have changed. The opinions are locked in and have been for decades. The final point I'd like to address is that this bill is being rushed through the Parliament. People are latching onto this argument to oppose the bill in its entirety. That's an opportunistic political argument, in my opinion. However, I do note that the House has resolved to extend the period of consideration of the bill for at least 4 more weeks, giving the members a chance to study the Social Issues Committee report, read the relevant Hansard of evidence and consult with their communities. But to argue that this law reform has come out of nowhere is to do a disservice to the advocates for law reform going back to the 1960s. I thought highly respected Wendy McCarthy, AO, former Women's Advisor to Malcolm Fraser and a founder of the Women's Electoral Lobby and chair of the New South Wales Pro-Choice Alliance, gave us a good history lesson at the inquiry when she said, in response to this very question, and I quote her, "First of all, I would say that in the early marches of the second wave of feminism in Australia and New South Wales in the late 1960s, and she participated in those marches, abortion was an issue brought to public attention. I think in the 1970s, education and reproductive rights were always seen as the two gateways to a woman's autonomy. The conversation has never changed. This is a continuing story of women seeking autonomy and women being free from prosecution." End of quote. And that, Mr President, brings me back to where I started my speech, the strong women in my life, my family and my friends. I put it to the House that women must be empowered and trusted to make these difficult decisions about their bodies and about their own destiny. Women, if they seek to, can capably consider the significant moral question that this decision entails for so many, including those who are religious. But that's their choice. And very importantly, the medical profession can then provide a person-centric medical service without fear of prosecution. Mr President, I strongly support the bill on behalf of all the women I love and care about.
The Honourable